Today on BenchBriefs, we're looking at a landmark Supreme Court of Canada decision that grapples with one of the cornerstones of the legal profession, solicitor-client privilege. The case is Lavallee, Rackel Heintz v. Canada, Attorney General, decided in 2002. It's a story about protecting confidential communications between lawyers and their clients, and how those protections stand up against the demands of criminal investigations. So, what's this all about? Imagine you're a lawyer and the police or prosecutors want your files or to hear what you discussed with your client. Normally, the law protects those private conversations. That's solicitor-client privilege, ensuring clients can speak openly with their lawyers without fear that their secrets will be shared. But in this case, certain provisions in the Canada Evidence Act allowed the government to compel lawyers to hand over documents or testify about those confidential talks in specific situations. Several law firms and lawyers challenged these rules, arguing they violated their clients' rights and the principles of fundamental justice. Here's how it unfolded. The Crown, or the government, was pursuing criminal investigations and sought access to lawyers' records and testimony about communications they had with clients. For example, in one of the cases, the government wanted documents from a lawyer's file because they believed it was necessary for their prosecution. This raised alarm bells. The lawyers argued that these provisions in the Evidence Act forced them to break their duty of confidentiality. They said this not only undermined solicitor-client privilege, but also violated Section 7 of the Canadian Charter of Rights and Freedoms, which protects life, liberty, and security of the person and guarantees principles of fundamental justice. The key legal question before the Supreme Court was whether these statutory limits on solicitor-client privilege were constitutional. More specifically, did compelling lawyers to disclose confidential communications or documents infringe on the charter rights of lawyers and their clients? And if so, could that infringement be justified under Section 1 of the Charter, which allows reasonable limits prescribed by law to be upheld if they can be demonstrably justified in a free and democratic society? At the heart of the case was a balancing act. On one side, the justice system needs access to evidence to prosecute crimes and ensure fair trials. On the other, solicitor-client privilege is an essential safeguard that promotes trust and candor between clients and their lawyers. If clients fear their secrets won't be kept confidential, they might withhold information, which could undermine the whole purpose of legal representation. The Supreme Court carefully considered these competing interests. The court reaffirmed that solicitor-client privilege is a fundamental right, deeply rooted in the principles of justice. It protects not just the lawyer and client, but the integrity of the entire legal system by ensuring clients can communicate fully and honestly with their counsel. The court recognized that the privilege is not absolute. It can be limited, but only in very narrow and justified circumstances. In this case, the court found that the provisions in the Canada Evidence Act did infringe on solicitor-client privilege, and thus on the principles of fundamental justice under Section 7 of the Charter. However, the court also examined whether this infringement was justified under Section 1. The government argued that these limits were necessary to prevent abuse of the legal process and to allow the Crown to access evidence in criminal proceedings. The court ultimately ruled that the statutory provisions were too broad and did not adequately protect solicitor-client privilege. They struck down the parts of the Evidence Act that compelled lawyers to produce documents or testify about confidential communications unless very strict conditions were met. This decision reinforced that any limitation on solicitor-client privilege must be carefully tailored and justified so as not to erode this vital protection. Why does this case matter? Lavallee, Rackel, and Heintz v. Canada is a foundational ruling that clarifies the strength of solicitor-client privilege in Canadian law. It underscores that while the justice system needs evidence to function, it cannot come at the expense of the constitutional rights that protect the fairness and integrity of legal proceedings. For lawyers and clients alike, it sends a clear message. Confidentiality is sacred and essential to the administration of justice. This case also highlights the role of the Charter in safeguarding fundamental legal principles against overreach by legislation. It shows how courts step in to maintain the delicate balance between competing interests in our legal system, between the state's power to investigate crime and the individual's right to a fair process. Thanks for listening to this episode of Bench Briefs. Join us next time as we explore another important case shaping Canadian law and justice. Until then, take care.